you to believe that the same gun that didn't destroy a face, going the same way, somehow did destroy a face, but they can't tell you why, they can't tell you how. There's a problem with that. Also, ladies and gentlemen, the man that can tell you when someone died and how someone died, he never said Mr. Johnson's body was out there all night. He never said, based off of his training and his experience, that this dead body was outside. And you're going to hear me talk about this a lot because it's extremely important. Everything that the state wants you to or wants you to believe the witnesses said about Durez was true starts right there. Think about this, ladies and gentlemen. The state wants you to believe that a dead body was outside in the woods when it was raining heavily, and then when the body was found, it was dry. This doctor never said that he saw an infestation of maggots, like I said. This doctor never said that there were animals that did something to the body. So what the state wants you to believe is this body was out there for over 20 hours, and yet not a single insect or animal came to it and disturbed it. He never said he saw signs of any of that. And that starts to mean something when you want to listen to the state, because the state wants you to believe Durez killed Mr. Johnson the same night he allegedly killed the other two. Their experts never said that, ladies and gentlemen. There's a problem with that. Now, Dwayne High. Again, ladies and gentlemen, the state wants you to believe a person that they don't fully believe. The state wants you to trust a person that they don't fully trust themselves. How do you do that? Now, they put Dwayne High on the stand, and we know Dwayne was lying. Like, just listen to the story he told Demeester 10 years ago, and the story he didn't tell, the story the state pretty much forced him to tell when he took the stand. But what he says is Durez came to his house, killed 3 people, no, slaughtered 3 people. I think they used the word executed. Dwayne went upstairs to get his mother. They both put on their clothes, got in the car, and drove Durez to a gas station to help him get gas to burn the car. Does that make sense to any of you? Use your common sense about this. If your cousin comes up to you and says, yo, I just killed 3 people, help me get rid of some evidence, are you gonna get dressed in the middle of the night and do it? It doesn't make sense. And the state never addressed why you should believe what Dwayne High was saying. I mean, you saw when he was up there, the state wants you to believe that Dwayne High was so afraid of baby Durez, 18-year-old Durez, that he didn't want to talk. It's not true. Dwayne was pissed off because it was obvious he didn't want to be questioned for the first time. Demeester never questioned him. Demeester literally took him for his word with everything he said. The state never questioned him. Dwayne, what Durez tell you? Okay, then what happened next? Ladies and gentlemen, when I got up there and started questioning him, it was clear he didn't want to talk to me. He didn't want to say a word to me because this is the first time in 10 years somebody actually got to call him out on his BS. He's never had that in 10 years. The people that put him on the stand that they want you to believe, they know most of the stuff Dwayne High said wasn't true. How do you believe a witness the state doesn't even believe, ladies and gentlemen? Well, let's talk about this. Dwayne said on the stand that his mother drove to the gas station, Durez followed in the car behind him. Dwayne told Demeester 10 years ago, Durez got in the car and his mother drove and they all were in the same car. Both of those can't be true. The state knows both of those can't be true, but even then they didn't question Dwayne. Even then they didn't say, well, wait a minute, let's go back. You really remember how many cars that were there? Why is that? That was obvious. Dwayne then says after they get the gas, they go to a vacant lot. That's what he told you. 10 years ago, Dwayne told Demeester after they got the gas, they drove back to his house. Again, the state knew that wasn't true. The district attorney knew that wasn't true, yet they didn't question him on it. 10 years later, it's coming out and they're still not questioning, and all of you are the ones that are supposed to get the information. All of you are the ones supposed to process, do I believe this person? You know the district attorney didn't believe him because he never questioned him on it. Let me just skip over that part. Maybe the jury won't pay attention to it. Ladies and gentlemen, how are you supposed to make an informed decision when they're purposely choosing not to inform you about all of the information? They want you to believe somebody, but they don't believe them. They failed their burden. They failed their promise. Now,
And I'm going to get to his story with everyone else because the DA kind of lumped that together. I just want to hit the high points before I do get to their story. But again, they don't believe what he has to say. Now, in regards to the burning car, yes, a car was set on fire. We saw the pictures of that. Here's the problem. Dwayne High wants you to believe that Derez did it. The state wants you to believe that Derez did it. 10 years ago, Dwayne never said, I saw Derez pour gasoline on the car. He didn't say it here. 10 years ago, Dwayne never said, I saw Derez light the car on fire, and this is how he did it. Didn't say it here. The state knew that. And again, they had the opportunity to tell you. They had the opportunity. All right, Dwayne, now let's take it step by step. What did Derez do when he got out of the car? They didn't do that. How did Derez light the car on fire? They didn't do that. Did Derez pour the car or the gas on top of the car or inside the car? They completely ignored it. Why is it that they didn't want that information to come out for you? It's because Dwayne doesn't know. The reason Dwayne doesn't know because he didn't see Derez do any of that because Derez did it. Dwayne knows who did it, but it wasn't Derez. Those are the little things. Even if Dwayne can't tell you what exactly he put on that night, even if Dwayne can't tell you what time it was. If you see someone burn a car or set a car on fire, and that's your cousin, you at least know how they did it. You at least remember, did they pour the gasoline on top or underneath? He couldn't even give you the basic information. Now, the DA yesterday called that filler. I want y'all to look at the filler and not the big picture, but that's not filler, ladies and gentlemen. Those are the basics. You want to determine if someone's lying or not? Listen to the little things that they should understand. Who drove the car? That's something you don't forget. How many cars were there? That's something you don't forget. Where did you go? That's something you don't forget. Those aren't little small details that you forget, like the color of your shoes that night. That's something you will always remember, especially when it's a family member that tells you, I just executed 3 people, and now I need you to help me get rid of evidence. The state never talked about those inconsistencies because they don't have answers for them. Because they know Dwayne High was lying back then, Dwayne High is lying now, and they don't have answers for them. Again, if you ask yourself, can I trust Dwayne? They have to tell you why you can't. And they have to tell you that the DA can't get up here and say, you know what, everything Dwayne said, I believe him 100%. And this is why, and this is how. What the DA wants to do is what they're doing throughout this entire trial is they're picking little bits and pieces and they want you to see their story. They want you to see it their way without giving you all of the information. And again, how do you make an informed decision when they are purposely not fully informing you for that decision? Now, Latrice Williams, that's Dwayne High's mother and it's Derez's aunt. Again, has the state given you a reason to believe her? Has the state given you a reason? Do you feel comfortable right now saying, you know what? Everything Ms. Williams said on that stand, I believe. The answer again is no. Because again, it doesn't make sense. My nephew comes to me and says, I just executed 3 people and I get dressed and I help him out. That doesn't make sense. And ladies and gentlemen, she said stuff during this trial that she hadn't said in 10 years. The state knew about those inconsistencies. Didn't talk about it, didn't want her to talk about it anymore. Number one, she says she knew Derez had $459 exactly. It's not true. She never said that to anybody until she comes in and sits on the stand and tells you that now. Number two, she tells you that after she went to the gas station, she didn't come back to her house because she was so afraid of Derez. And then we find out, well, no, she came back to the house because she tells you she dropped Derez off of the car. Inconsistency the state never addressed. Then she tells you, I am so deathly afraid of Derez. He just did all this. What did you do next, Ms. Williams? Oh, I drove him to a vacant lot where there's nobody else around, just me and my son. But I'm so afraid of Derez. I'm scared of him, me and my son's safety. So she drove him to a vacant lot. No cameras, no businesses, no people. Does that make sense? The answer is no. But then again, the state knows that doesn't make sense. They never addressed it. And again, she never describes to anybody how that car was set on fire. She didn't say I saw Derez pour the gasoline on there. She didn't say I saw Derez use a lighter. She didn't say I saw Derez use matches. Again, the little things that she should know about and the things that the state should have said, okay, let's back up a bit. Let's walk the jury through this. Every time I talk to a witness, you heard me say it. Now you see the jury is taking notes and writing it down. So let's go step by step. Why won't they do that? They don't want you to go step by step. They want you to hear and see what they want you to hear and see and skip over everything else. Why would you do that? The biggest thing, ladies and gentlemen, the gas can is right here. You'll get to see a picture of it and you'll get to see the bag and take it out of the bag if you want to. She even lied about the gas can. Oh, well, it wasn't that gas can, it was a second one. Why would the investigator Demeester take a picture of a gas can that wasn't involved in the incident? Furthermore, if Dwayne and Miss Williams really had nothing to do with this, why would they hide the gas can afterwards? That gas can wasn't just sitting next to the house. It was literally, when you see the picture, it was tucked under a bench and there was stuff all over the bench. And if you were looking in the street, looking towards the house, you couldn't see it because there was stuff blocking that too. You literally had to walk up, get on the porch and look under a bench to find the gas can, but they want to tell you that they have nothing to do with this, they have nothing to hide. Furthermore, gas can didn't come back with fingerprints of Derez. Why is that? Because Derez didn't use the gas can. Derez was not with them. And the state never tried to bring up any of these inconsistencies because they haven't done it in 10 years and they don't want to do it now. Don't worry about that, ladies and gentlemen. It's filler. For them, it's filler. The basic things are filler. Don't focus on that. Just listen to what they want you to listen to and believe them because they say it. We're not going to prove it to you. Just believe me because I say it. That's not how this is supposed to work. And ladies and gentlemen, let's just say you believe that they were involved. Dwayne Hyde was never arrested. He was never even brought into custody and interrogated. Miss Williams was never arrested or brought into custody and interrogated. They literally took part in hiding evidence in a triple homicide, and they got what, a talking to by investigator Demeester? Does that make sense? One thing that's really important that the state never addressed, and this is sad. 10 years ago, Dwayne Hyde, when he was talking to investigator Demeester, he said, you know this is bigger than just Derez, right? Demeester agreed with him. And the state got up here after I brought that out because they did it the first time. And then he tried to ask a question to Mr. Demeester about why he said this was bigger than Derez. The state doesn't even know who said what anymore at this point. They've been saying their conversation, their story for so long, they can't tell you who said what and did what. Dwayne Hyde was the one that said it. Yet the DA asked investigator Demeester, why did he say that? Then there was no follow-up. The state didn't ask, well, can you explain what did Dwayne Hyde mean by that? There was no follow-up because, ladies and gentlemen, we know what it means. Demeester admitted it. He knows what it means. This is bigger than Derez. One person didn't do this, and I'm going to explain more when we get into it. A group of people did this, and Derez wasn't involved. That group that I'm talking about are all of these people that have similar stories, but they can't get the finer details that make sense the most. Those are the ones that are involved, and I'm going to explain how a little more. But this is bigger than Derez. They never address what that really meant because they don't even know who said it. Demario Davenport. Now, he is implicated in this murder. Before the officer ever spoke to Demario, somebody says, you know what? I saw Demario in the car with Derez and Mr. Hyde and someone else. Investigator Demeester goes to Demario, and the first thing Demario says is, I've been waiting to talk to you. Demario didn't go to investigator Demeester. Demeester had to go to him. Now, what Demeester says is, look, you were implicated in the car, in the murders. Were you there? No. Did you do it? No. Okay, who did it? Derez. Okay, let's talk about that. Again, does that make sense? There was no real follow-up from the lead investigator, ladies and gentlemen. He literally said, did you do it? Demario said no. And then like, all right, well, tell me who did. Let's talk about Derez. Ladies and gentlemen, investigator Demeester told you at the time, Demario was on parole, just got out of prison for doing the exact same thing. He was on parole for armed robbery, for going in and doing something with a weapon that he got punished for. Now he's back out. Demeester knew that. And again, he wasn't even questioned or detained to have a full conversation. Why is that? It doesn't make sense, ladies and gentlemen. And the state can't address it now because Demeester never gave you an honest, real answer of why his thorough investigation didn't thoroughly investigate Demario Davenport. Even though you want the state to believe a witness, he was in the car right after it was done. He was part of it. Who do you believe? You believe the witness that the state tells you he was in car, or you believe Demario, who is also the state's witness, says he wasn't? You can't have it both ways, but they never addressed it. Because for them, that's filler. Oh, God, 10 years, I don't have that answer. Let's just call it filler and move on. Ladies and gentlemen, that's not filler. This is the point where they have to give you that answer. And the DAs, they didn't do it. They purposely didn't do it because they can't. The reason they can't was because 10 years ago, investigator Demeester never fully, thoroughly investigated this case. And now it's too late. Erica Bauer. Now again, state can't tell you that they believe everything she said is true, because we know certain things aren't right off the bat. Erica Bauer said that Jerez told her he pistol whipped Bubba. There was no signs of Bubba getting pistol whipped in the back room. The doctor didn't say there were signs that Bubba was pistol whipped. Again, the DA knew that, didn't ask her to clarify. Well, what do you mean? When you say pistol whip, what exactly did Jerez tell you? Why is that, ladies and gentlemen? They know it's not true, but they don't want you to talk about it because to them, it's filthy. Now let's talk about the rape. Ten years ago, Erica Bauer told investigator Demeester that Jerez raped her right before he was murdered. The DA knows that. 10 years later, Erica Bauer comes in here and says Jerez raped her. The DA knows that. The DA now wants to say that it was some kind of sexual contact. Let's stop there for a second, ladies and gentlemen. If you're a police officer and a woman comes up to you and says, oh, I didn't know, a person comes up to you and says, look, I was raped. There are certain steps that that officer has to take. You didn't hear any evidence about that because Demeester never believed her and blew it off. Why? Because this isn't a thorough investigation. The DA, his office's job is to prosecute crime. So if the DA believed that she was raped, there were certain steps the district attorney was supposed to take. So as of right now, it went from rape to some kind of sexual contact. So that means they don't believe Erica Bauer was raped, part of what Jerez did, part of what she's saying Jerez did, which means you don't have to believe that either because they don't, or they're just going to throw that to the side because they don't care that Erica Bauer was raped. How do you go from, ladies and gentlemen, listen to my witness, believe what she's saying, she's telling you he was raped, to some kind of sexual contact? That's a question they have to answer. Well, they can't now because their evidence is cut. But just think about that when you move forward. Now, after they had the conversation 10 years ago with Erica Bauer, after Erica Bauer came in, the DA then played her interview with Demeester. And again, she talks about rape. Now, investigator Demeester and both of the district attorneys knew that those messages existed between Jerez and Erica Bauer. They didn't show you them. We know they had them because they'll show you a bunch of other messages from Jerez, but why didn't they show you those messages? Because those messages are what they want to talk about, direct evidence. That's direct evidence that you can't believe what she was saying. That's direct evidence that what she told you on this stand was not true. The district attorney knew about it, ladies and gentlemen. And what blows my mind is they know I have the same evidence they do. They know I know about these messages. They know I hear and see everything that happened in this room. How did they not think I was going to bring that up? Now, if this is their case and they're putting it all out there for you to see, why didn't they address it first? Is that filler for them? That's a question they can't answer at this point. They didn't address it. I'm the one that had to do it. What was it? A couple of days? No, the day after Jerez allegedly raped her, slaughtered 3 people, and then bragged about it while she was in his house. She's texting him, I love you. They never addressed that. How do you make an informed decision when the people asking you to make the decision don't fully inform you? They purposely choose to leave that information out. That's important. Now he's got a couple minutes left. I can't wait to see how he addresses it because they never addressed it during the trial. They never addressed it when they were presenting their case. So they can't say anything new. That's the question that needs to be answered. Chelsea Brewer, she's the one that I heard 6 shots, heard 5 shots, 15 minutes later, I heard 3 more. Then it was, I heard 5 shots, heard 6 shots. It sounded like an automatic. Now the state made a whole big deal about the fact that she lives in an area where you hear gunshots all the time. That's true. I used to live right off of Hollywood Road for a year and a half too. Yes, we heard shots all the time. But ladies and gentlemen, if you hear shots all the time, you know the difference between an echo and an actual shot. That makes her more reliable with what she says, not less. But she can't tell you how many shots there were because she's lying. Those are the little basic things that it's not I heard somebody tell me. She's saying I specifically heard these shots. We know from the evidence from the autopsies that didn't happen. 2 shots in the house, 3 shots out back. We don't know when the other 3 out back happened, but even if you add them up, it's 5. It's not 13 and 11. The state knows that, but they didn't address it. They tried to cover that filler up with, oh, it could have sounded like echoes. Ladies and gentlemen, common sense tells you that's not true. And again, that's an answer the state has never given you. Now, this was interesting because 10 years ago, she never said this, but now in front of all of you, she does. She says, after Durez killed 3 people, after she hears the shots, Durez goes to a food mart or something. She willingly walks to the food mart with Durez and some unidentified man, and then listens to them brag about killing 3 people. Then when I questioned her about it, well, you didn't go to the cops, did you? No. You didn't tell law enforcement, did you? No. Her answer, ladies and gentlemen, she had never said in 10 years. My baby's father punched me in the mouth and busted my lip when I spoke out about Durez. Does that make sense? Baby Durez at 18 has so much power that if you talk about him, the father of your children will open your lip, will make you bleed. The state wants you to believe that Durez did all this because he wanted to be the king of the streets. It sounded like he already was. If you talk about 18-year-old baby Durez, the father of your child will punch you in the face. Does that make sense to anybody? And the fact is the state knows she never said that 10 years ago. Why didn't they address it? Again, it's an inconsistency that the state presents to you and they say nothing about it. That is a problem, ladies and gentlemen, because again, if they don't believe their witness, how are you supposed to believe it? If they don't trust what their witness is saying is true, how are you supposed to trust that it's true? How are you supposed to make an informed decision when the people asking you to make the decision doesn't properly and fully inform you? There's an issue there. The white safe. 10 years ago, she is the one person that did talk about the white safe. She never said Durez said he took the white safe. Demeester never told you that. She never said Durez was seen with the white safe. Demeester never told you that. What she said when Demeester was with him, did you see or did you find the white safe? 10 years later, now she's saying not only was there a white safe, but the white safe was in the woods. Well, ladies and gentlemen, I showed that picture of Mr. Johnson's body up there just showing his feet because he had on white socks. We saw how the small white sock stood out in the woods. My first question to you, ladies and gentlemen, does it make sense that you put a white safe in the woods and that's not going to stick out? How do you hide a safe full of drugs and money and it's painted all white in the woods? There was nothing out there that showed that that safe was buried. There was nothing out there that showed a hole was dug. There was nothing out there that showed there was brush or anything like that covering the safe. And I asked those questions. The state didn't. The state didn't say, Investigator Demeester, explain to us how that safe was out there. He couldn't. Investigator Demeester, explain to us the signs that showed that that safe was out there. He couldn't. Now, ladies and gentlemen, if it's a safe in the woods, there would be at least an imprint in the ground. Wasn't there. So first off, if I'm now the drug kingpin of the street, that means my white safe has to be big enough to carry a lot of drugs and a lot of money. That's not something that's just going to be easily hidden in the woods. Number two, if I'm the kingpin of the streets, why would I paint it white? Why would I make it white? And I put it out there with dirt. That makes no sense whatsoever. They don't address it. Also, let's think about this. 18-year-old baby Durez somehow carried a white safe that's big enough for a drug kingpin. He walked back, he took 167 steps back to a fence that's 5 feet tall. So pretty much his height. He got him and the safe over the fence, yet there was nothing to determine that that safe like hit the ground. So we're saying that Durez, baby Durez at 18, somehow put this big safe on his hip and climbed a 5-foot fence and then came over on the other side. Does that make sense? Common sense tells you if a drug kingpin safe goes missing and they have to get over a fence, there's only 2 ways to do that, ladies and gentlemen. Number one, you pick it up, drop it over the other side. If you're by yourself, climb over there. You would see something on the ground, sometimes with dead. Or number two, you're doing this with somebody else. You pick it up, hand it to them, they grab it, they start walking, you jump the fence and go. There were no signs that somebody picked up a big safe and dropped it on the other side. And there's no way 18-year-old baby Derez is carrying a drug kingpin safe over a fence this tall as him, and he just had it in one hand, he climbed to the other. And if you believe the state, he had the safe in one hand, had a gun in the other hand, and he climbed a 5-foot fence. Doesn't make sense at all. But they don't address it because to them, that's filler. In 10 years, they've never been held accountable for it. And so right now, they have no answer for it because that's filler to them. It's not important to them. It should be important to you. Now, ladies and gentlemen, the state put this in their closing yesterday. Should I do it? Should I not do it? What they want you to believe is that Derez sat on the couch and said, should I do it? Should I not do it? Not only did he sit on the couch and say that, but he told witnesses he said that. Investigator dubious never heard that from a single person 10 years ago. He never took the stand and said Derez, or someone said Derez told him that. The first time you heard that was from his lips. And then he put it all over the closing, the PowerPoint on the big screen so y'all can all see. That never happened. It was never said. Derez never did that. The state knows that never happened 10 years ago, but they put it on the big screen for you to see. Why is that? Because they want you to see this story the way they have been telling it for 10 years. Not the way it is, not the truth. Think about that when the state gets back up here. Mr. Pullins, 10 years ago, Demeester never said that he said anything about a white safe. 10 years later, he talks to the state, he takes the stand, now there's a white safe, and now it's in the back. Still, he didn't describe his white safe. He didn't tell you how big it was. He gave you no details other than there's a white safe, and now his memory is better 10 years later than it was at the time of the incident. State didn't say, well, Mr. Pullins, why didn't you talk about the white safe 10 years ago? Why didn't you tell Demeester where that was 10 years ago? They didn't address it because it's not important to them. But that's a question you should be asking yourself. Your memory doesn't get better over 10 years. It gets worse. But if it's a huge white safe that a drug kingpin has, you can at least describe it. He couldn't describe it. He just said white safe after talking to them before he took the stand. That's a problem. Now, ladies and gentlemen, the gun. Mr. Pullins tells you that he did give Tim Jackson a gun. I believe that, and someone else says he did it as well. But this is the important part about the gun, ladies and gentlemen. Mr. Pullins never said there was an issue with his weapon. Mr. Pullins never said, you know what, that ejector rod is messed up on his weapon. Mr. Pullins never said, in order for me to close the cylinder, close the barrel, so I can actually fire the weapon, you got to do something to the ejector rod. That's important when we move further. It's his gun. He would know that better than anyone else. Now, the state could get up here and say, well, he was incarcerated. How would he know? Ladies and gentlemen, I asked Investigator Demeester, how long was he in jail or was he incarcerated before he gave Tim Jackson that gun? He didn't know. We don't know if it was days. We don't know if it was weeks. We don't know if it was months. All we know is when he gave him a gun, there was no issue with the gun. Now, we also know that he gave the gun to Tim Jackson. He never said Tim Jackson could use the weapon because he said that. He never said Tim Jackson could give the weapon to someone else because he said that. Hold this gun until I get out. That's all he said. So, ladies and gentlemen, if that was the same gun, how did Derez get it? There was no testimony that Derez said, hey, I know where this gun is and that's where I got it. Think about this. Somebody tried to rob Tim Jackson before. Mr. Johnson did. And what happened when Tim found out? That was his family. He picked up a dumbbell and beat him in the head so badly they had to go to the hospital. So you think Derez took a gun that Tim Jackson had and Tim Jackson knew about it? No. The state doesn't address that. You think Derez had a gun that Tim Jackson was supposed to be holding? Tim Jackson knows it's missing. Apparently, everyone in the city knows that Derez has it because he showed everybody. So that means Tim Jackson knows about it as well, yet he didn't do anything. So he'll beat his own cousin over the head with the barbell for stealing, but he won't to Derez. Why is that? That doesn't make sense, and the state knows these inconsistencies. Again, never talked about it, and that's a huge problem. Investigator Sauls. He is the gentleman that came back on the police force, fugitive task force. He arrested Derez. Extremely important, a couple of things that he said. We know Derez was arrested December 16, 2013, 2:30 p.m. Now, ladies and gentlemen, when an officer arrests somebody and that person has a gun on them, there are a couple of steps that officer needs to take. They don't put that person in the back of a squad car with the gun still on their hip. First thing they do, they take the weapon. Second thing they do, they clear the weapon. They make sure there's no ammunition in the weapon and that it's safe so it cannot fire and shoot somebody. Now, for a revolver, ladies and gentlemen, you know what that means? He opened the weapon. He pushed the ejector rod, because that's what it does, to get the bullets out. And then he closed it. He manipulated, or he didn't look at it, he used it exactly the same way it was supposed to be used. And he never reported that there was an issue with that ejector rod. He never reported, I cleared the weapon and there was an issue, and it was hard for me to close that. He never told Demeester that. So now we have another person that never said a gun that Derez had actually had any issues with. That's important because the state wants to tell you that the weapon that Ms. Murphy talked about is the weapon Derez had, and it killed everybody. Well, ladies and gentlemen, between the time it was allegedly taken from Derez and the time it got to Ms. Murphy, there wasn't a single witness that they put up there that said, you know what, I looked at this weapon and there was an issue with it. You know what, I was testing this weapon and there's an issue with it. You know, there was a problem with this weapon and I told investigator Demeester. There's something in law enforcement called a chain of custody form. What that means is if evidence is collected, the first person that collects it, they fill out the form, fill out what it is, where they got it from, what their name is, their badge number, what time, what day, what they did with it. If they want to tell you that the weapon that was used is the same weapon that was broken somehow later on, they would have said, look, we can explain the steps. We can explain why this ejector rod is messed up now. They didn't do it because they can't, ladies and gentlemen. Again, show your worth. Believe me because I'm telling you this is true, but I'm not going to show you that it's true. Believe me because I'm telling you this is true, but I'm not going to show you how I know it's true. How are you supposed to make an informed decision when the people asking you to make the decision don't fully inform you? Is that filler for them too? Is that filler for you? Common sense says that you would have known that weapon was damaged the very beginning they opened it and actually used the ejector rod. Anyone down the line that had this weapon that says, you know what, it's damaged, we would have had notation of it. We didn't until the very end, and they can't tell you why. And that's a problem. Officer Ward and Officer Descharnes, those are the first two officers that came to the scene that night. And I'll just be really quick about them. The only thing you need to understand about them is first two officers that took the scene, but none of them or neither of them checked the backyard. Officer Ward tells you when he went to the scene, he didn't know there were dead bodies. He just knew somebody was shot. So in his mind, active shooter maybe? You don't know, it doesn't get ruled out. He gets there, finds two people were shot, knows there's a third person who's not in the house, and his job wasn't to clear the area. He literally said he let somebody else do it. But then when I asked him, well, who did it? He couldn't tell you. Officer Descharnes, second officer there, tells you the exact same thing. Well, yeah, somebody cleared the area, it just wasn't me. And I straight up asked him, so you just waited for somebody else to do it? He said, yes. When did to protect and serve turn to be, I'm gonna show up and let somebody else do it? 16 officers were there. You're trying to tell me that the state doesn't know which one went to the backyard and actually checked that backyard, checked the scene? The reason why you can see that information, ladies and gentlemen, is because there was no disturbance back there. There was no signs that anything happened where people were going over that fence. There was no signs that a safe was being moved back and forth. And he wanted to talk about a dog. When y'all saw the dog, I mean, was that a vicious dog? The dog pretty much posed for the picture, ladies and gentlemen. And Investigator Demeester wants to tell you, well, he checked the scene, and he looked back there, but he didn't check everything because that dog was vicious. He never put that in his complete and accurate report. Now, those of you that are familiar with police reports, this is how they do it. When an officer searches, they say, I searched this area, I searched this area. If there's a part of the area they can't search, they say they can't search it and they say why. He never said, I couldn't go to this area because there are aggressive dogs back there. That was never said until right now, and it's not true. If it's not in the report, ladies and gentlemen, it's complete, accurate, thorough report, it's not true. They can't give you an answer of who searched the backyard, which is ridiculous, because we know somebody did, and that somebody would take the stand and tell you, we didn't see any disturbance. They don't want you to think about that because, again, I guess that's that filler that I'm talking about, but they don't focus on. Officer Demeester. You've heard me talk about him a lot, so I'm not going to stay on it long, but a couple things I do want you to know. So when Dwayne High said, you know, this is bigger than just Derez, Demeester's exact words, which he agreed to, were, you think Derez is that smart, really? You think that fucking guy, this kind of a brainiac, is going to come up with this whole thing? Why would he say that? Now, when he spoke with the DA, he spoke with me, he never said, oh, I just told Dwayne that to get him to keep talking. He never said, oh, I was joking with Dwayne, so get him more comfortable with it. People believe that because it's true. Baby Derez at 18, who's been around these grown men since he was 13, 14 years old, he didn't do that. It's bigger than him. He wasn't mature enough or smart enough to do this at 18. All these other people that have been in and out of prison for these same reasons, they're the ones that were. All these other people that are trying to tell you these stories about Derez, but they don't all add up, they're the ones that were. This was bigger than Derez, and he said it himself. You think that fucking guy is kind of a brainiac that's going to come up with the whole thing? No, he didn't. He wasn't a part of it, but he is the fall guy because it was Baby Derez. He's the easiest one to pin this on. Now the cell tower, the state wants you to, well, first off, first cell tower they talk about is the one by Gary Street. Ladies and gentlemen, Derez lived like 4 houses away from that house. Of course, his cell phone is going to ping off the closest tower to that house if he's home. That doesn't mean he was in the house. Even Demeester couldn't say that he was in the house. He, what was it? It's a 2-minute walk from Derez's house to that house. Of course it's there. Now, they also want to say that puts Derez at the vacant lot. It does not. The difference between Derez's house, where the scene of the crime happened, and Dwayne High's house, that vacant lot, is literally like 3 or 4 blocks. And Demeester said he can't pinpoint exactly where this was. All you have to do is leave Gary, walk 2 blocks, and now you're hitting another tower. They can't tell you how far or how close Derez was, but what the state told you was that puts him in the vacant lot with the fire. That's not true. Demeester never said that, and they can't prove that, but in their closing, that's what they told you. Why is that? They didn't tell you the actual distances. They put him in that vacant lot, and they cannot. So the question is, why do they keep telling you things that aren't 100% true, aren't necessarily true, if they want you to believe the truth? The picture of Derez. Showed it during the trial, showed it yesterday, showed it today. Extremely important, ladies and gentlemen. Throughout this entire trial, the DA has literally testified better than any witness that he's put on the stand because he's telling them what to say. In regards to the picture in Derez, the first thing he asked, what does that look like in his hand? The first thing that comes out of Demeester's mouth, a stick or a pole. What happened next? Demeester didn't say the word shotgun until he said the word shotgun. Does that resemble a shotgun? Oh, yeah, that's a shotgun. Ladies and gentlemen, that's the one that testified out of everyone else. Again, what color was the watch? Demeester said, I don't recall and I can't tell from there. Again, the DA said black, green, and red. Demeester says, oh yeah, black, green, and red. Who's testifying here? Who's the one that took the oath and got on the stand? Why is it? Why is it that he's telling people what to say at this point? 10 years now, they should have this back and forth. It should be like them playing catch. What is this? Got it. It's that. Got it. They couldn't do it even now because nobody's story matches up. Why is it that the DA has to testify and tell investigative Demeester what to say? Because when you look at the picture, ladies and gentlemen, it looks like a broomstick. That's exactly what it looks like, and that's what he's. When you look at the watch, you can't tell what type of watch it is. You can't even tell the full colors, but the DA will tell you what it is. Why is that? You're supposed to make these decisions on your own, yet the DA is testifying for everyone takes a stand, and they're telling you what this is. I'm not telling you what this is. I'm commenting on everything because I'm the one that has to do it because they won't. Again, how do you make an informed decision when the people asking you to make the decision don't properly and fully inform them? He's giving you answers. He's not letting you come to them, and that's a problem. Oh, when it comes to the jacket as well, first thing Demeester said was raincoat. And then the DA said, well, doesn't it look like a trench coat too? He's like, oh yeah, trench coat or raincoat. There's an issue there, ladies and gentlemen. We as attorneys, what we say isn't evidence. We as attorneys, we're not supposed to testify. The evidence and testimony comes from up there. The judge is going to tell you that. It doesn't come from this podium, and it doesn't come from the DA's office. James Johnson, I already talked about the body, so I won't do it again, but this is the important thing you need to understand about James Johnson. What the DA just told you was that his phone was last used at 7:55 p.m., which means he wasn't alive after that. Is that true? Does that make sense, ladies and gentlemen? Right now, what time did you get into into the back room? 9 something? So you haven't used your phone since 9 a.m. It's what, 10:20? Are y'all dead? Are any of you still alive? That is a blatant lie. That is just ridiculous. How does that make sense? All that means is the phone wasn't being used after 7:55 p.m. They still have to explain how the body was back there undisturbed for like 20 hours. Ladies and gentlemen, I can't stand in my backyard or lay in my grass in my backyard without getting bit by ants in literally 5 minutes. But this dead body stood back there for 20 hours and nothing happens to it. And it was heavily raining. Ladies and gentlemen, think about this. Use your common sense. The blood and brain matter was undisturbed. What does that mean? That means water never got to it. This wasn't a light sprinkle, it was a heavy downpour. That's what the Demeester said. Now, even if his head is laying on the ground and all the blood and brain matter are right there, 2 things would happen if a heavy downpour happened. Number 1, the water would soak into it and soak into the ground. We didn't see that. Or number 2, what does water do when it can't go down? It moves. So then the water would have soaked into the brain matter, the blood, and it moved. That never happened. They don't address it. Why is that? Water is one of the strongest elements on the planet. You don't stop it unless you hold it in something. There's a reason the brain matter and the blood was in a pool right there, because it never was there when it rained. They don't address that. None of their experts say that that body was out there when it rains. They just want you to believe it. And to help you believe that, he didn't use his phone after 7:55 p.m. He was dead. Show your work. That's all I'm asking right now. Now, yesterday, the state told you there's direct evidence and circumstantial evidence, and that's true. The judge is going to read that to you. But what the DA told you that's not true is that the gun is direct evidence that Derez committed these crimes. 100% not true. The gun is direct evidence of there's the gun, but it's still circumstantial evidence surrounding A, Derez with that gun, and B, was this the actual gun? Now, I'm going to go over these quickly because you heard me say some of them, but this is important. What the state has to prove is that the weapon that was used was the weapon that was found on Derez, and the weapon that went through all of those tests, and the weapon that finally came back that was the weapon that killed 2 people. Ejector rod issue, talked about it. They can't explain any of that. We'll move forward. Now, the blood tests. This is extremely important. We know Derez was arrested December 16, 2013. We know in investigative Demeester's report, which he knew about and the DAs knew about, there was a report where, and I'm going to butcher this test, so I'm going to say it's a P test. 1 test was conducted on the gun that allegedly came from Derez, negative color reaction, which means it did not react to say there was blood. Ladies and gentlemen, the issue with this report, it shows that the handgun was received the day Derez was arrested, but it showed the handgun was received at 5:45 a.m. Derez wasn't arrested until 2:30. The report was actually created at 8 a.m., 9 hours before Derez was arrested. Simple question. How do you write a report of a gun that you tested, that you're saying is the same gun that you collected 9 hours before Derez was arrested with the gun? They had no answer for it. Neither did Demeester. At one point, he tried to say, well, I don't know what time it is. I had to remind him, wait, you're law enforcement. You use military time. It said, 5:45 hours, 0800 hours. Issue there. Does anyone have an answer from the state? Did they tell you, this is why I know this is wrong, but this is how we corrected it? Demeester can't tell you who wrote the report. Demeester can't tell you who did the test. Demeester can't tell you anything about it, but it's in his investigative report, which he has gone over and the state has gone over. We know also the same day, after Derez was arrested, crime scene tech Felder tested the gun, and she used 2 tests, not 1, the LM test and the P test. Both of them came back positive. So ladies and gentlemen, now we have 2 tests from a gun. One doesn't make sense because it couldn't have happened when the gun was actually collected. And they say the exact opposite. One says the test was negative, the other says the test was positive. Ladies and gentlemen, The state never told you about those tests. I did. The state never brought up the fact that there are inconsistencies with those tests. I did. Investigator Demeester never talked about it at all. I did. The only test they wanted to tell you about was the one that Ms. Orline did, where she used both of the tests again, and it came back to a color she'd never seen before. That's kind of insult, because again, the state knows I have this evidence. The state knows I'm going to talk about it, but I guess that's that filler that they're talking about. Now, ladies and gentlemen, this is why they can't tell you enough about the gun. Because if their expert, who's been doing this for 11 years, tells you, I have never seen this color in my life, I have no idea what this means. They have to have an answer for that. They didn't ask those questions, but I did. Well, does it look like someone used some type of chemical to get the blood off? She said no. Does it look like somebody used some type of cloth or something to get the blood off? She said no. So now, ladies and gentlemen, the state has to explain the ejector rod situation. They have to explain these planted, I guess, report situation, and they have to explain what happened in the end there. There has to be a chain of events that they show you to show, look, what I'm telling you is true. They can't give you that answer, but they want you to believe that that was the gun that was taken from Derez. That was the gun that was used, and Derez is the one that did it. Don't look at my work, ladies and gentlemen, just believe me because that's what I say. It's too late for them to do that. They went through a grand jury where no defense attorney was there. Derez wasn't there. I didn't get to question anybody that took a stand. I didn't get to question what the state said. They literally got to say whatever they wanted. You would think 10 years later, they'd be a little better at this argument. They don't address it, and there's a problem for that. They can't 100% show you that these are the steps we took, and that's how we know this is the gun that was used, and that's how we know this is the gun that was taken off the rails. That's a huge question because everything else falls apart with it. Excuse me, with that. Now the rap song. I have to actually read this because I didn't know how this is the definition of it, but so the rap song, ladies and gentlemen, what the state did was they played this song. They were allowed to play it because that was them showing you Derez's mindset at the time after the shootings. That was them showing you Derez's, what he said today was Derez's confession. He was telling you how he did it, and he did it in a rap song. Think about how they presented this piece of evidence to you. First off, they played it with the witness and didn't ask the witness any questions about it. So they're playing it into your mind. They then get up, play it again with the second witness. But that second time, ladies and gentlemen, you remember the difference? Not only did they start asking Demeester questions afterwards, but they handed out a document to you. And what they told you was this was a document, a transcript of the song, so you can follow along with it. Ladies and gentlemen, the court reporter sits here. There have been 2 of them this week. The court reporter is the only one that can make an official transcript of evidence in this case. Neither court reporter did that. That came from the state. The state gave you something to read while they played it again. Now, ladies and gentlemen, it's called a demonstrative. This is what they did. My team and I were watching y'all the second time around. And what happened was, when they played the song again, you were listening to it, you were paying attention, what you're supposed to do. So afterwards, the DA got up, started asking Demeester certain questions. At that point, ladies and gentlemen, we saw most of you start underlining the areas in the song that the state was talking about. We saw a lot of you making annotations next to the parts of the song the state was talking about. Now, that's a technique that law enforcement and DAs are taught to do, and it's called framing. We're all humans wired the same way. Our frame of reference leads us to embrace and pay attention to some idea and to ignore others entirely. So what they did, the first time around, you were listening to it, receiving that information on your own frame. Second time around, now you have something you think is supposed to assist you. And then what happens? DA gets up here, talks about oil change, you underline oil change. DA gets up here, talks about house on fire. Oh, that's important now, house on fire. They're changing the frame of which you are perceiving this information. That's a problem. Because if they want you to think about this as rational, reasonable human beings, why are they forcing you to think about it your way? Ladies and gentlemen, even with the inconsistencies, the state didn't bring them up. Again, I had to. I'm the one that had to say, Demeester, have you ever heard someone reference an oil change as a murder? No. State made a big deal about it. Was there a house fire involved in this? No. State made a big deal about it. Jerez also said something, the people in the house owed him money. Is that true? No. They talked about it. People in the house owed him drugs. Was that true? No. The state talked about it. What they did, ladies and gentlemen, sadly, I can say it happens all over the state of Georgia because my team and I have trials everywhere. It's called framing. They change the frame of your perception and they force you to focus on what they wanted to and not what you were already focusing on. Why would they play tricks with you if they're just going to inform you of everything that is true? If they want you to make the decision, why are they giving you the answers? If they want you to believe the witnesses, why are they giving the witnesses the answer? They tried to trick all of you into thinking something that's not true, and that's a problem. And ladies and gentlemen, if they really wanted you to know the mindset of Jerez, they would have played those other videos. But again, I'm the one that had to introduce them, not them. Now, this is important because to set everything up, the DA asked investigator Demeester, when you were reviewing the videos, was there some that stuck out to you? Demeester said, yes, one. And he said it was the rap song. I had to get up there and say, but if you reviewed everything, you know there's a video where 18-year-old baby Jerez is walking through a cemetery and he actually says the names of the 3 men that died. That didn't pop into your head? Why is that, ladies and gentlemen? He's actually in a cemetery saying the prayer. Why didn't they want you to see that if they wanted you to know his real mindset? It's because we all saw 18-year-old baby Jerez grieving. 3 people that he's been around since he was like 13 years old just died. And he's talking about them and saying that I still feel like you're walking with me. Ladies and gentlemen, he's grieving and remorsing so much that he walks to a cemetery where his grandfather is buried, sits next to the gravestone and says a prayer. That's Jerez's mindset. They didn't want you to hear that. Why is that? The only one they wanted you to hear was a rap song so they could frame the way you perceive. How do you make an informed decision when the people asking you to make a decision doesn't inform you properly? Now, bunch everybody together like they did. The one thing the state's told you multiple times, I'm pretty sure they're gonna say it again. Well, even if you don't want to believe the filler, even if you can't believe everything their witness says, which they can't say that out loud because that's not possible, but even if you want to believe just the story that lines up, ladies and gentlemen, reasonable doubt. What is reasonable in your mind? Because everything the state has presented to you is circumstantial evidence. Not only do they have to show you that what they're saying is true, they have to also show you that every other reasonable theory is not true. Here's a reasonable theory, ladies and gentlemen, they don't ever address. What makes more sense? 18-year-old baby Jerez by himself picks up a hand cannon, shoots one person loud enough for people can hear him. Bubba is still asleep in the back. He runs to the back, shoots the second person, takes the third person outside, and carries away a safe that's big enough for a king. Or do multiple people come into this house? You have one person in the front room at gunpoint. You have a second person in the back at gunpoint. You have a third person, we don't know where, at gunpoint. Is that reasonable? Now, the state wants to tell you that nobody else would get into that house, but we know that's not true because multiple witnesses said, if you have enough money, Tim will let you in that house at any time of night. What makes more sense? Baby 18-year-old, 145-pound Jerez did this by himself, or multiple people came into a room. You stay there, you stay there, you stay there. Now the situation is controlled. Did they prove to you that's not true? The answer is no. And ladies and gentlemen, they always want to say that this was a kingpin. He's the new king of the block. Basic questions tells you that's not true. They want to show you how there were no drugs in the house. They want to show you there was no money in the house. And the table that the drugs were on, there was nothing there. Anyone that's ever seen a drug house before, either on a documentary, TV, or in person, if you're going to rob a drug house, why would you take the mirror with the residue on it? If you're going to rob a drug house, why would you take the baggies that have already been used? If you're going to rob a drug house, why take all the scales? If this is a drug business, they need something to suggest there's a business. Why would you take the ledger? Think about that. This wasn't a kingpin drug. We saw the inside of that house, ladies and gentlemen. The TV was like this big. The furniture wasn't great. There was a dinner table that was like this big that they were using. This wasn't a drug kingpin's house. The mattresses were on the floor. They weren't even real full beds. Where's the drug kingpin? Where's the king of the block? Where are the little things that suggest, yes, there were drugs in this house? Multiple, or not multiple, but a lot of drugs and money in this house. The rubber bands to stack your money. The money counter, because I don't know what drug kingpin counts their money by hand. Where's all that? If you're gonna rob them and kill them, why clean up afterwards? Oh, wait, get that residue off before I go. It doesn't make sense. This was not a drug kingpin. Something else that they keep trying to tell you, but they have never proved. They can't show their work. And again, ladies and gentlemen, I think it's ironic that yesterday the DA told you about your duty as a juror. And what he said was you have a duty to search for the truth, determine what really happened based off the evidence and common sense. How do you make an informed decision when the people asking you to make that decision does not fully inform you? When they continue to take evidence away and not actually present it to you? Now, this is very difficult for everybody, I understand. That's why we went through Word Diary to make sure that you were the right people for this job. I mean, you saw Derez over there, he's crying and just acting emotional during some of the pictures. Some of you actually did the exact same thing. We have people in the stands on both sides that were emotional. This is important. 10 years later, people were looking for answers and they're withholding evidence. They're withholding information. They're trying to skirt over the filler. 10 years later, it's still affecting people to this day. 3 men lost their lives and Derez is fighting for his liberties and they're withholding information from you.
And Your Honor, I have to object here.
Overruled, Mr. Trepanier.
Now you're going to hear about the burden of proof. Judge is going to explain it to you. Ladies and gentlemen, what that means is there's no mathematical certainty. When you go back there and you're making your determination, what you ask yourself, what the state presented to me, their investigation. If you think, well, Derez could have done it, that's not enough. If you think, well, Derez may have done it, that's not enough. If you think, well, there's a possibility that Derez did it, that's not enough. What you have to think in your mind, that I know beyond a reasonable doubt that the state proved their case to me. That all the evidence they presented showed me beyond a reasonable doubt that they upheld their promise to me. Now, ladies and gentlemen, when you get that verdict form, you go back there and you read it, it's not going to say, we the jury find Derez 85% guilty or not guilty. We the jury find Derez 26% guilty or not guilty. It's either yes or no. Did they meet their burden? Yes or no. Did they keep their promise to you? Yes or no. Ladies and gentlemen, I work for Derez. I represent them. I don't get to pick and choose everything I want to do. I don't get to just cut corners and only show you what I want. Because at the end of the day, I have to answer to Derez. He won't accept anything else. The district attorney and APD work for all of you. Your not guilty verdict today tells the district attorney that you will hold them accountable so they prove their burden beyond a reasonable doubt. Your not guilty verdict today tells investigator Demeester and every other officer like him, when you're the lead investigator on a triple homicide, we're going to hold you accountable. Make sure your report is complete and accurate and thorough. Make sure that you actually investigated every lead that you had and you didn't just pick and choose what you wanted. Because at the end of the day, you can tell the DA, you can tell APD that you won't accept anything less. Now, you heard the state said they're going to get up there after me. When I sit down, that's it. I can't rebut them or say anything else, but all of you can. Like I said earlier, if there's a question in your mind that they don't answer, they didn't meet their burden. If there's a hole in their case that they can't not only tell you about, but show you how they fill it and fix it, they didn't meet their burden. Ladies and gentlemen, it's been 10 years. I've known Derez for a very long time. I saw him grow up. This is the first time we actually get to tell his story. Thank you for making this possible for all of us.
Ma'am, Deputy, please remove her from the courtroom for the duration of this trial. Members of the jury, do we need a stretch break in place or would we like to take 5? I should have given, let's take 5. All right, thank you. I'll be back in 10:45.
Hey, you get my text, my email.
I'm sorry, I started and I was rushing out of here.
Do you do real time?
I'm not certified in real time.
But you're doing it.
I mean, yeah, I'm doing it, but it's not
Official.
perfect.
Yes, I thought we were applied for the position, and you didn't.
Oh, no, I didn't. Yeah, because I'm downstairs and you guys have me already.
What does that mean?
Huh?
We get your autograph.
Well, I autograph.
You look nice.
On the what news? Oh, I was trying to fix the equipment. Well, I have to look it up and show
Nightly news.
what channel. Okay, we're on Zoom. We're on. Vivian, come on here, because wait, the mics are off. The mics are on.
Wait, let me get my change my.
So were you coming here? We got sandwich.
Oh, yeah.
If you want it.
I was trying to change my batteries.
What kind of batteries do you need?
Oh, I have that.
Oh.
You have these? Out here, y'all.
Oh, well, you can just hide it.
I'm gonna just.
So you think I should mark the signed indictment as an exhibit? I've got it right. No, I've got it right here. We can just get him to sign another. Do you think we should just mark this one? Or just leave it unmarked?
We could mark it.
Okay.
Although I've never seen it marked.
Yeah, let's not do that. That's odd.
But I think that court reporter, she left it on the table
Just in the back here?
downstairs.
Oh, well, yeah, don't worry about it then. Mr. Hoover, here's another copy of the indictment, just so we have something to go back with the jury. And I'd imagine we sign this and date it as the first date of trial, whatever the date was that you signed the other one. And we can nunc pro tunc it or whatever you want to do. All right, Mr. Trepanier, you need any kind of a time warning? You've got 30 minutes remaining.
Just 5 minutes, Your Honor.
All right, I'll warn you in 5 minutes. Oh, never mind. Strike that, Mr. Hoover. I think we got the one you'd signed at the beginning of trial. So we'll have this one go back along with that verdict form. Ms. Smith, there you go. There you go. Yeah, I'll put it in the trash can. There we go. Okay. All right. If we could bring the jury back in, Deputy Scott.
Your Honor, you said this goes back to.
That'll go back to the jury. Yes, ma'am. We left off. And then if he comes back around. Thank you, Deputy Scott. Please be seated, everyone. Mr. Trepanier, you may proceed.
the defense argument. If I had to sum it up to different sort of pictures or images, the first is a squid, right? Inking the water, trying to make everything difficult for you to see. And that's what you heard, right? That's what you heard and saw when Mr. Hoover got up here and started talking, just to cloud the water, to muddy the water. But it's the same thing, think about it. Pebble into a pond. It's clear, right? The pond is clear. The water's sitting there. You can see the bottom. See the truth at the bottom. Let's call the bottom those facts, right? The defendant's doing is taking a little pebble or a rock and throwing it into the water, causing those ripples, right? And those ripples, you might look at it for a second and you have a moment of, okay, maybe I'm not so sure. Just take a second. And that's what we're here for. Take a second and you realize that the truth comes back. It comes into focus once you think about all the facts in this case, as you've heard them. This is Derez Sanders' obvious guilt in this case. What lawyers say, the questions we ask, the law, as we're explaining to you, ultimately are just that. The law is going to come from the judge. You're going to get it, and you're going to hear it, right? The facts are what you heard. The facts are what you make of them, okay? All those witnesses, everything that they said. So use your notes, all right? Use what you heard, use your common sense, and it'll all become clear. And it is clear, okay? It is clear in this case. I want to talk about a couple things. Let's talk about just firearms identification, since it was brought up for a considerable amount of time. Firearms identification goes back 100 years. 100 years. Jennifer Murphy said that. She's been a firearms examiner, identifier since 2010 when she started doing independent casework. That gun was functional. And she was able to compare that gun to the bullets that were in those victims' heads, and they matched, right? The gun that Derez Sanders had, the gun that multiple people say Derez Sanders had prior to these murders. Okay? You also kept hearing about, many times, baby Derez. The 18-year-old rapping about taking that 4-4, taking it, I'm the one who come to see you, I'm the one who bust, shooting. Baby Derez. Baby Derez is gonna lay the whole house down. Derez told you he did it. He told you he did it. And not only that, he told lots of people that he did it. Told lots of people. And those witnesses that got up here and who talked 10 years ago, they gained nothing 10 years ago by talking to the police. They gained nothing from that. A lot of them didn't want to cooperate. And yet, ultimately they gave statements. And they got up on the stand, and again, they gained nothing from that. And they testified, and you heard from them. And you heard about what happened. There was an overwhelming consistency between these witnesses when you think about it. Overwhelming consistency as to what happened, the order that it happened. All of the evidence that corroborates what they're saying, all that physical evidence. The state is relying on the relevant facts. the relevant facts that show that Derez Sanders on November 22nd, 2013, early in the morning, was in that house, stood behind Tim Jackson, shot him in the head, went to the bedroom, shot Roberta Sawyer in the head, and then took James Johnson behind the house where the drugs would have been kept, shot him in the head, took him behind the house. And there's one last thing, we'll get it to when we get into some of my common sense. What was brought up was this multiple people, right? Multiple people. Multiple people are in that house while Tim Jackson is playing video games with his headset on and a controller in his hand with a cigar in the other hand. Right? Cigar, controller, and there's just multiple people in this house. No, it's someone that he trusted. It's the person who stood behind him, and shot him in the head. That person being Derez Sanders. So why did Hot brag? Because you heard it from multiple people. He told us that he didn't.
Life is about choices. Life is about taking recognition.
Life is about choices. Life is about taking recognition. Taking recognition. Taking recognition for what you've done. That's what it is. Taking recognition. He said it himself. Listen to Hot himself. Listen to him. You've listened to him in many ways through multiple different people, right? You listen to him through Detective dubious, where Hot made a story about how the people in the house weren't around, and then you heard that that's true, right? And then you hear Hot talking about beforehand via text messages and via conversations what he was planning on doing. And then you heard Hot after the fact talking about, should I do it, should I not do it? I was thinking about doing with Reese Williams. Then he killed those 3 people. Right? Like he told Tim, or like he told Mr. Chisholm. You heard that on the statement. You know Tim? I did that. I did that. So common sense. Let's use our common sense because that's incredibly important when you think about this case. Derez Sanders killed these 3 victims to get money, drugs, and How do we know that? Well, one, he planned it. He talked about it. And you have witnesses who are not necessarily even directly involved. Rico Evans, for example, being like, yeah, he came up to me, had a whole bunch of money and drugs he didn't usually have, okay? You have multiple witnesses saying, hey, he showed it off. He was showing it off to us. Recognition makes sense. You heard the term king of the block. King of the block. Wanted that recognition. There are no other reasonable alternatives as to what happened that night. There's no other reasonable alternative. Common sense. Okay. This isn't some grand conspiracy, right? This case is not a grand conspiracy where Erica Ballard, Demario Devon, Dwayne High, Jarvis Chisholm, Tarsha Gaither, Latrice Williams, Rico Evans, Gabriel Hodges, Michaela White, Chelsea Brewer are all creating this massive conspiracy that's out to get Derez Sanders. That they're all coming up with the same story of what happened that night. All of these people end up telling the pieces of the same story, despite all these people not being connected. Despite all these people not being connected. They're not all friends. You didn't hear that everybody spent time with everybody else. You got all these pieces together. You know, Jarvis Chisholm is not related to Miss Latrice Williams or Dwayne High. Erica Ballard, again, not related to Jarvis Chisholm. There's all these different pieces here. Common sense, right? Derez Sanders was arrested with the gun that killed these victims. That memorable, old, rusty cowboy gun. The thing that you would not forget, right? To try to argue, there's no argument for that not being the gun, right? So let's use our common sense. We know that the bullets in Tim Jackson and Rubery Sawyer were fired from the same firearm. And we know that that firearm was that .44 Magnum revolver that Derez Sanders was arrested with. So let's talk about James Johnson. There is, as you've heard, a gunshot wound, multiple gunshot wounds to James Johnson, basically in the same part of his head. There's that entrance wound right there. Common sense, the way that each person was shot, it's the same. It's the same. Right? And they recovered a lead core from by where Mr. James Johnson was. It just was not suitable for comparison. Right? Jennifer Murphy said that once it was the way it was, there's nothing that she could do. Okay. Wasn't killed at a different time. There are maggots in his wound. Maggots are maggots. Maggots are maggots. Right? Phone records of the last call time. Yes, the last call he placed was 7:55. And yes, and never did I say that he died at 7:56. What that shows, though, is that on November 22nd, the next day, he's not making any calls. Nothing. Nothing is happening with that phone. Consistent with the other phones, consistent with the time that Gabriel Rogers, here's the gunshots, right? consistent with Derez Sanders calling his cousin, the same cousin who 2 days before he's texting to come over and basically hit the lick, and telling him, if you're gonna come here, you gotta hit through the door or hit through your jacket. So reasonable doubt. I want to go through this just a little bit again. But one of the most important things, it's not a vague doubt. It's not a vague doubt. It's not an arbitrary doubt. And you are not to seek doubt. I think you did it. Guilty. I think you did it. You did it. Guilty. But I want. This is when you start seeking doubt. It's that qualifying. Right? That's not reasonable doubt, that's seeking doubt. And you are not to seek doubt. You're going to hear that in the instructions that you give. Right? There's not a reasonable doubt in this case. Because what do we know? There was planning. It's not reasonable to think Derez Sanders gave up his plan from 2 days before after texting his cousin. Planning. It's not reasonable to think that this is just some random event with other people when you consider the crime scene and the crime scene photos, right? That's not reasonable. That's vague, that's arbitrary. There's no evidence of anything like that. And the planning is corroborated through multiple witnesses. Right? And there's not some grand conspiracy here. Erica Ballard is talking about, killing somebody. DeMario Davenport is talking about hitting a lick. Dwayne High, he's talking about hitting a lick. What do we know? Action, execution. Action and execution. Kills Tim first, Bubba second, L third. Yeah. Reasonable. It's the only reasonable way that this played out. And we heard it through multiple people. He told multiple people the same thing. You didn't hear anybody sit here and say, or hear any statements that said, well, actually, he went out to the back first, and then he came through this and did. No, everybody was consistent, overwhelmingly consistent as to what Derez Sanders told them, which is consistent with the physical evidence. That the trusted person is in the house, that the person sitting there awake in that living room who's playing video games is there. That person gets shot by Derez Sanders, that he goes to that back room where the individual's on or near the bed, right? Shoots him. And James Johnson, inside, takes him, walks into the back where the drugs are, executes him there. It's the only reasonable alternative, or only reasonable way this plays out. And what do we know? Taking recognition. He immediately begins showing off those proceeds. Like he said, life is about choices. Life is about taking recognition, getting that clout, being respected, being king of the block. Bruce Williams and Dwayne High, they see it. They see the money. They see the drugs. They see the car. That car that's then taken to 2275 Brooks Avenue, right? And it's burned. Starts telling other folks, showing off the drugs and the money. walking around with it. It's got the Gucci watch, the red, green, and black watch that Jarvis Chisholm sees. The same person who he says, yeah, you know Hot, or you know Tim? I did that. Jarvis says, yeah, I knew Hot. That Tim? Yeah, he did it. And then told Jarvis, yeah, this, what else? So in this case, said life is about choices. The only reasonable outcome is to find Derez Sanders guilty on all counts. Derez Sanders made his choice to kill Timothy Jackson or Barry Sawyer and James Johnson. Now hold him accountable. Okay. Choose guilty on all counts. That's like I said before. You're not telling Derez Sanders anything he doesn't already know. You're just recognizing for him what he did. Thank you.
All right, members of the jury, that concludes the closing arguments in this case. And it is now my role to instruct you. I'm required by law to deliver or charge you on the law that applies to this case. And after that, we will then have you retire to the jury room to begin your deliberations. And we'll talk about that more in a minute in this charge. You'll also receive a copy of the indictment and of these charges. So this should take about 20 minutes, I would say. You are considering the case of the state of Georgia versus Derez Sanders. The grand jury has indicted Mr. Sanders with the offense of murder, 3 counts, felony murder, 6 counts, armed robbery, 3 counts, aggravated assault with a deadly weapon, 3 counts, arson in the 2nd degree, theft by taking, and possession of a firearm during the commission of a felony. You will be provided of a copy of the indictment during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation in the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charge, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you and the charges to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. and may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. The jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those that, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to challenge the credibility or believability of any witness. This would include evidence of bias toward a party, such as specific instances of conduct of the witness in question that may relate to the witness's bias toward a party, or felony convictions, namely proof that a witness has been convicted of a felony. In determining the credibility of any witness whose credibility has been challenged, as I've described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony or statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. You may consider evidence of habit of the witness if shown, insofar as it may show, if it does, that the conduct of such person at the time in question may have been in keeping with such habit. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of the state in which there's a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe it existed from a proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of a sound mind and discretion are the product of that person's will, and that a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such inference or inferences is a matter solely within the discretion of the jury. Georgia law provides that voluntary intoxication shall not be an excuse for any criminal act. It further provides that if a person's mind, when not affected by intoxicants, is capable of distinguishing between right and wrong, as well as reasoning and acting rationally, and the person voluntarily deprives himself of reason by consuming intoxicants and commits a criminal act while under the influence of such intoxicants, that person is criminally responsible for such acts to the same extent as if the person were sober. Whether or not the defendant in this case was voluntarily intoxicated at or during the time alleged in this indictment is a matter solely for you, the jury, to determine. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime, either in fact or because of legal incapacity. Knowledge on the part of the defendant that the crimes indicted were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes indicted were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A person commits conspiracy to commit a crime when that person, together with one or more other persons, conspires to commit any crime, and any one or more of such persons does any overt act to bring about the object of the conspiracy. A conspiracy is an agreement between two or more persons to do an unlawful act, and the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by any party to the conspiracy to further the unlawful enterprise is considered to be the act of all the conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter for you to determine. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to the inference of the existence of a conspiracy. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive may be admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Armed robbery and aggravated assault with a deadly weapon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of armed robbery and or aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For armed robbery, the state must prove that the defendant, 1, took another person's property, 2, directly from another person and from the immediate presence of another person, 3, by using an offensive weapon, and 4, with the intent to commit theft. An offensive weapon is an object that is likely to cause, or actually does cause, death or serious bodily injury if used against someone. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of arson in the second degree as to any vehicle when by means of fire he knowingly damages or knowingly causes, aids, abets, advises, encourages, hires, counsels, or procures another to damage any vehicle of another without his or her consent. A person commits theft by taking when that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken or appropriated. When value is an element of an offense, the value must be proved by the state is fair market value of the property at the time of the taking. Fair market value is defined as the price agreed upon by the seller who is willing but not compelled to sell and a buyer who is willing but not compelled to buy. I have defined for you the offense of theft by taking as defined in our code and as alleged in this indictment. Value of the property alleged is that additional element that must be proved by the state. So in that connection, I have charged also that the state must show that the value of the property taken by the defendant was more than $1,500. The form of your verdict should also include your finding as to the value increment supported by the evidence beyond a reasonable doubt. We, the jury, find the defendant guilty of theft by taking valued at more than $1,500. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person, 3, while committing a felony, which is a crime against or involving another person. Armed robbery and aggravated assault with a deadly weapon are felonies, and the term firearm includes any handgun. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. The law provides that criminal action shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by circumstantial or direct evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of this court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County did, on or about November 22nd, 2013, commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of an offense, or you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment has the court has made during the progress of the trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. As stated during jury selection, the death penalty is not applicable to this case. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should not give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. And members of the jury, we will have a verdict form that has already been pre-printed listing each of the charges, and that's going to be provided to you along with the appropriate exhibits in this case. At this point, are there any objections to the charge as given from the state? Mr. Hoover? All right. So in a moment, I'll ask for you to retire to the jury room with the exception of juror number 43. Jury 43. All right, ma'am. If you could stay behind with us just for a moment. And with that, thank you. All right, thank you, Deputy. Juror number 43, you might have gathered that there were 13 of y'all this week, and you are our alternate. So at this point, we don't see a need for you to stay in the building unless you want to. We would have to have you separately in a different room. But what we want to offer is, if just as we did during jury selection, if you could keep your phone on for the remainder of today. And we are going to give you an update by 5 o'clock today, whether your service is concluded or whether we also need to have you on call for tomorrow. And so if we still have you on call for tomorrow or any day after that, again, we're going to ask that you can be here. How long do you think it would take you to get to this courthouse from home or wherever you are once you get that phone call?
Depending on the time of day, it may take anywhere from 30 to 40 minutes.
That's perfectly fine. So we'll request that you stay on a 1-hour call approximately. And again, we're going to give you an update at the conclusion of today, whether you're going to remain under that. But regardless for now, once you leave the building, once you go home while you're still on call, the same conditions apply where you can't talk about the case to anyone or even including among your family, and you can't do any research about the case whatsoever. Understood? All right. So we'll have you exit out through the same way you've been coming in every morning. And also we do still have, I think the sandwiches have already been delivered. And if you want to grab one with the deputy before you leave, feel free. Okay. If we don't see you again, thank you so much for your service. Okay.
Thank you.
All right. And deputy, if you wouldn't mind walking back with her just to let her get lunch. So we make sure they haven't started deliberations. All right, so at this point, council, if we could gather everything up that we need to send back, and then we'll note the time when that happens. That's right. That's going to be the one. We'll put that with the indictment and the verdict form. The old one, just, you can make part of the record if you want, since we've marked it as an exhibit.